father who was convicted in the hot car death of his son is fighting to get a new trial. On the hot, humid morning of June 18, 2014, Justin Ross Harris strapped his 22-month-old son, Cooper, into the rear-facing car seat in his SUV before heading to work.
And I know how much he loved Cooper. I mean, he loved Cooper with his whole heart. I mean, there wasn't nothing he wouldn't do for that child. He
cherished him.
Yeah, he did.
Surveillance video captured Harris holding Cooper and ordering breakfast at a Chick-fil-A near their home. After leaving the restaurant, Harris said he intended to drop off Cooper at a daycare in the Home Depot headquarters in Metro Atlanta, where he worked as a web designer. But after he left work, Harris says he made a devastating discovery. Little Cooper was still in his car seat. The toddler had been trapped in the hot car for more than 6 hours, with temperatures in the vehicle reaching above 100 degrees. An autopsy later confirmed Cooper died of hyperthermia. Harris was arrested later that night. And after a 3-month investigation, Harris was indicted by a grand jury and charged with 8 counts, including malice murder, felony murder, and cruelty to children in the first degree. Prosecutors added more charges after they found that Harris had been sending sexually explicit text messages to at least 6 women, including a teenager.
They tried to make it look like he was sexting on his phone knowing his child was in the car.
And that's not true.
He was sexting on the phone, there's no doubt about that. But they never did prove that he knew the child was in the car.
Investigators say in the days before Cooper's death, Harris made online searches related to babies in hot cars, statements that would later prove untrue. Nevertheless, the damage was done in the court of public opinion. Harris's attorneys asked for a change of venue because of extensive pretrial publicity. Harris's mother, Evelyn, told Court TV the media attention was unbearable.
And everything was so publicized before the trial that there was no way he could have gotten a fair trial. No way, because the press had him pronounced guilty before his trial.
The judge agreed and moved the trial 300 miles southeast of Metro Atlanta to the coastal city of Brunswick in Glenn County, Georgia. During the trial, prosecutors portrayed Harris as a man who had been living a double life. They said he intended to kill his son Cooper because he wanted to live a child-free life. The jury heard testimony from several women who Harris had been sexting on that fateful day. But the defense said Harris was a loving father who experienced a memory lapse, who simply forgot to drop his son at daycare. Harris's then wife, Leanna, said he was forgetful and absent-minded when she testified for the defense.
Was he the kind of person that was very focused, or was he easily distracted?
I would say he's easily distracted. I guess a good example would be, maybe getting a paycheck and forgetting to cash it.
After about 5 weeks of testimony, the jury convicted Harris of murdering his son Cooper. The judge praised the jury for its verdict when she sentenced Harris to life in prison without the possibility of parole.
They fairly deliberated and discharged their duties and found the defendant guilty of what factually was a horrific experience for this 22-month-old child.
Now, 4 years after he was sentenced, Harris wants a new trial. His defense attorneys say the court denied Harris a fair trial when it failed to sever unrelated charges tied to his sexual infidelities and sexting an underage girl. The defense says the court forced Harris to defend himself against a charge of intentional murder of a child after drowning the jury in morally reprehensible bad character evidence.
When that story first broke, and I covered it from the beginning, there was incredible sympathy for that father. People were like, my goodness, he just made the biggest mistake of his life and they're arresting him? This is outrageous. And then people learned a little bit more about Ross Harris, and yeah, public opinion, swayed a little bit to say the least. Another important fact about that trial, he never testified. right? Yeah, I know you don't have to testify, but prosecutors accused him of purposely torturing his 22-month-old son, and he never got up on the witness stand and explained how that happened, how he forgot, what he was thinking about. I think he should have testified, but that was just me back in 2016. It's 2020. Monday's a big day. Let's bring in the best team of legal journalists in the business with us tonight. Court TV legal correspondents Chanley Painter and Julie Janae, and Court TV anchor Julie Grant. Great to see everyone tonight. Chanley, what do we expect next week in Cobb County, Georgia?
Well, we expect that Ross Harris's motion for a new trial hearing will start around 9 a.m. Monday. It'll be in Cobb County. We're expecting it to last 2, possibly 3 days. Now, in this defense motion, it's 30 pages long. He alleges around 24 separate grounds, or what the defense calls reversible errors, made by the court before and during that sensational trial. And these grounds range from prejudicial testimony alleged by the defense, through bad character evidence, through allegations that the detectives lied in their sworn statements to judges, and that the court prevented them from cross-examining those detectives on the witness stand. Now, on Monday, we're expecting the defense to call 4 witnesses to put on its case before the judge, including the 3 attorneys who represented Harris back in 2016, as well as an expert on memory. Because remember, his defense during the trial was that this was an accident, that his memory failed him. And so we'll hear from those starting on Monday. Now, the prosecution here is alleging that this was still intentional murder. There's no grounds for a retrial here. They aren't intending to call any witnesses, but we should be seeing some arguments and visual aids on their behalf starting Monday.
All right. Chanley, can you just highlight a couple of the grounds that they're alleging here so we can dive into them?
Absolutely. So there's 24 separate grounds. Some of those grounds involve evidence rulings by the trial court judge, such as the severance of counts or these prior bad acts. Others involve certain pieces of evidence that were introduced during the trial, the visual elements, the recreation of the car and the crime scene, animations or demonstrative aids that were introduced during the trial. Each of these grounds in different sections, some for the weight of the evidence, some based on constitutional grounds, and some just they accuse as abuse of discretion by this trial court judge. This is one of the first steps for him in a very long, probably, process for an appeal of his convictions.
All right. Julie, let me ask you, let's start with the severance, because that's probably the biggest one, right? Because he's charged with sending these really nasty, vile pictures back and forth with an underage girl. She's not an adult. She's underage, sending them back and forth. And prosecutors are saying, listen, that's all part of the motive here.
Correct, Vinny. And from the defense standpoint, they're saying that this was a real problem, because hearing all of that information about the 17-year-old and the sexting and all of that terrible conduct, that clouded the jury's judgment. And it's easy to really understand why. When you look at the indictment, there were 8 counts against Justin Ross Harris, and counts 1 through 5 all dealt with baby Cooper's death. And then counts 6 through 8 dealt with him sexting this woman who was 17, sending nude photos and very explicit sexually charged text messages and whatnot to her. But the defense is saying there was no link. Prosecutors put forth a narrative for the jury that Justin Ross Harris wanted to live a childless life, that he wanted to be child-free and he had to get rid of Cooper. And so that's why he left him alone in that hot car to die. But when you really look back at the evidence, and I can't wait to see what's presented in this motions hearing, the prosecution has to make a connection that you can't just say, oh, okay, well, so he was a liar, he was a cheater, he was a bad spouse, he was despicable, he acted like a... No, there has to be a connection. And I think defense has a really, really strong argument here that those charges should have been separate, totally separate trials. Because if the jury hates him for being unfaithful to his wife, for preying on a 17-year-old, my gosh, I mean, they're going to look at him with such disgust. How could they possibly look at him with the presumption of innocence, which is required in a court of law? And then to pile it on, prosecutors piled on more bad character evidence pertaining to that theory of him wanting to live that childless life. And Vinny, they called women who had had affairs with him a year before little Cooper was dead. What connection is there with that? I mean, you have to be so narrowly tailored when you invoke that rule of evidence. So again, I think that's the other big ground. To your point, joinder, number one, and then two, it's going to be that propensity problem. I think this prosecution really has. I wouldn't be surprised if he gets what he wants here and gets this conviction overturned and he gets a new trial.
Let me ask you one question, because you're the professor. What if he had just pleaded guilty to that because he did it? I mean, the pictures were on his phone. It was very obvious that he was guilty of sending these pictures to an underage girl. What if he had just pleaded guilty to that before the trial? Would that have kept that information out?
Right. There would be no way the prosecution could introduce that. I mean, they really couldn't. The only thing that the prosecution can do, like, for example, in the way of convictions, let's say there would be a crime of deceit on his record. Like, let's say he was guilty of shoplifting, 5 or 6 years before this. If he took the stand and if he testified, they could cross-examine him on that conviction. But they could not come into court, even if he did take the stand, and say, oh, by the way, let's introduce your criminal conviction for this other case. Just can't do that. So, and again, it's for this reason, right? Because you don't want the jury being prejudiced by prior bad acts that don't fit under some kind of exception to the rules of evidence. And so he certainly could have. He could have owned up to that. But, perhaps he wanted to exercise his right to go to trial. And that is his right. But it's a real shame that these cases weren't severed, because it sounds like it was quite a mess. And that jury got inundated with a lot of information that really didn't prove to be probative of the crimes alleged. I wonder why, Vinny, there wasn't a plea to involuntary manslaughter. I mean,
I have
if
a
he's
feeling it wasn't
acknowledging
offered.
the death.
Yeah, I don't think it was. I don't think it was necessarily offered at the time, and maybe I don't think we were really privy to the back and forth there. Julia,
Sure.
let me ask you about the jury view. I love jury views. I want the jury to see the scene of every crime if possible, and they have a problem with the jury view here?
The defense has a huge problem with how this jury saw the car at the center of this. They got that up close and personal view of this car. It was taken to the courthouse. You see it there being driven to Glenn County, where these jurors were actually able to go outside into the parking lot and walk around this car, looking in it, poking their heads inside the driver's side window to get a perspective of what this was like and understand what the crime scene may have been like. But the defense is saying that this was a misrepresentation because these jurors were able to see it from every angle. But in the actual commission of the crime, Justin Ross Harris would have only been on the driver's side and looking from a particular perspective. So they say in trying to figure out whether or not he should have known that Cooper was in the back seat, that really skewed things. But that's not the only way that they were able to take in this car. There was also an animation that was shown to this jury once they were back in the jury box. And it shows the movements of Ross Harris that day and shows the measurements and dimensions of the car that was involved, this Hyundai Tucson. But there's one thing in particular that the defense had an issue with. In this rendition, it's a little bit skewed as far as the dimensions. It's a few inches off, so they say that was one misrepresentation. They also have an issue with the way the roof disappears there and makes this vehicle look different, makes it look like a convertible car. And they say that there's impression that these jurors likely got from seeing that, thinking that it was more likely that Ross Harris should have known Cooper was in the back seat if this was indeed a convertible. The defense calling that a lasting mental impression that likely went into the jury deliberations with those jurors.
Yeah, I'm not buying that because they had the view. They saw the actual thing. They knew it wasn't a convertible. And by the way, this is when he went at lunchtime. He went out at lunchtime that day with his friends, and I think he went somewhere, bought some light bulbs, brought them back to his car, opened the door, put the bulbs on the front passenger seat, and then closed the door and went back to work. And again, according to him, didn't see Cooper, didn't smell Cooper either at that moment at lunchtime. And prosecutors had their own theory that he was going to put a show on for his friends, that he discovers Cooper at lunchtime, but that didn't happen. There's surveillance video of all that. All right, Chandler, let's talk. I almost forgot to talk about the memory expert. Ironic, right? What's going on with the memory expert in this case?
Maybe you need to go see him, Vinny. I'm just kidding. But yes, he's a big witness for Monday for this hearing. Now, he was supposed to testify in the original trial in 2016, but did not testify on behalf for the defense. He's a nationally recognized expert in memory, Dr. David Diamond. He actually, in his research, coined the phrase forgotten baby syndrome, and he's sought after for a lot of these type of trials all over the nation. But he will be testifying Monday basically on what he would have told the jury during the trial back in 2016, which is that what his research is, what factors go into caretakers leaving children in the back of a hot car, and he will examine the Harris case here and share his opinions and his thoughts on how that applies to his research. Of course, his ultimate conclusion is that this was not intentional, that this was an accident. And Dr. Diamond's name actually comes up multiple times in both motions for the new trial for the defense and the state's response, because the defense alleges that the reason they didn't call him in the original trial is because the prosecution successfully had the judge compel the defense to hand over what they call confidential work product of the expert for them. And they thought that was improper, gave the prosecution an unfair advantage knowing some of his thoughts and his notes. And so they decided not to call Dr. Diamond during the trial. So they're calling him Monday now for the motion for a retrial.
All right, this is it's gavel-to-gavel coverage, folks, okay? The whole team is on there. Chanley, Julie will be up at the courthouse. Julie Grant will be right where I'm sitting right now, bringing it to you in the middle of the day. So it all starts Monday, 9 a.m. One thing, though, the same judge is hearing this motion, so you've got to convince the judge that she made some improper rulings in like the highest profile case I think that she's presided over. That I think is another challenge, but we shall see. Fascinating stuff, incredible trial.